I hope I'm audible. Good afternoon, respected bench. With the permission of the bench, might I refer to them as your lordships for the remainder of my submissions and my co-counsel submissions. Much obliged. I will be taking up 25 minutes of this court's time, whereas my co-counsel will be taking up 30 minutes of this court's time for his respective submissions. Before I proceed, would your lordships like a brief summary of facts? Much obliged, lordship.
Please identify yourself.
Your lordships, we are representing the petitioners, your lordships.
Petitioner.
Yes, your lordships.
You are Clean Court T29P.
T29P, your lordships.
Sure.
Much obliged, your lordship. Proceeding with a brief summary of facts, your lordship, Mr. Ratan Murthy, your lordships, would you mind if I do it without the mic? Much obliged.
So long as your audible is fine.
Yes, your lordships, I hope this is audible.
Your lordships, Mr. Ratan Murthy, the CEO of New Tech Private Limited, helped in the creation of artificial intelligence known as AlphaReal. AlphaReal had a randomized feature through which users can create songs and videos. Using this randomized feature, New Tech Private Limited wanted to create the first ever artificial intelligence written album. AlphaReal did this through its randomized feature, wherein it created fiction flow, wherein the lyrics, the composition, and the flow of the album was completely original, which I will be dealing with in my second issue, your lordships. Your lordships, moving on, we try to apply before the appropriate authorities for the grant of authorship under the Copyright Act. However, this was denied, and we approached the High Court post this. The High Court also denied our relief. Therefore, we are before this honorable court under Article 136 of the Constitution of the Republic of India. Your lordships, furthermore, Mr. Ratan Murthy took a break from his tasks as CEO and went back to his successful blogging career, wherein he created certain skits and parodies which very well fall within Article 19, Clause 1, freedom of speech powers of Mr. Ratan Murthy. These videos were taken down in pursuance to the IT rules of 2023. Therefore, there are 4 issues before this honorable court. The first issue being whether AlphaReal, the artificial intelligence, can be granted legal personhood with certain legal duties and obligations. Number 2, whether AlphaReal can apply for authorship under the Copyright Act. Number 3, whether there has been a fundamental right violation on behalf of MC Buzz through Mr. Ratan Murthy. And number 4, testing the constitutional bias of the IT rules of 2020. Your lordships, me, Counsel 1, would like to proceed with the first 2 issues, that being whether AlphaReal, the artificial intelligence, can be granted legal personhood, and number 2, whether AlphaReal, the artificial intelligence, can apply for authorship under the Copyright Act. With the permission of your lordships, I would now like to proceed to my first issue. Much obliged, your lordships. Your lordships, the first issue to reiterate is whether AlphaReal, the artificial intelligence, can be granted legal personhood. Your lordships, Black's Law Dictionary defines legal personality as any being upon which legal rights and duties can be placed upon. Your lordships, in extension to this definition, we are asking for a limited legal personhood be granted to AlphaReal, the artificial intelligence, so that it can apply for authorship under the Copyright Act. Your lordships, to present our case, we will be drawing analogies from pre-existing cases wherein entities or inanimate objects have been granted legal personhood. Your lordships, there has been certain criteria which the Supreme Court of this country has looked into, and in furtherance of that have granted certain legal personhood to inanimate objects or entities such as companies, religious idols, as well as trees and rivers. Your lordships, I would like to present 4 prongs of arguments. Number 1, or 4 prongs of arguments or criteria which the Supreme Court has used to determine whether legal personhood can be granted to these entities or inanimate objects. Number 1, that the entity serves a benefit or an interest with its interaction with humans. Number 2, that there must be a gap within the law which exists, and this gap is rectified through the grant of legal personhood. Number 3, that the entity must be clearly identifiable. Number 4, that again, there must be a specific purpose which is being fulfilled, such as in the case of trees and rivers, it was the case of ecological or a sociological purpose which was being fulfilled. And finally, your lordships, the grant of legal personality has been done on the basis of change in historical circumstances. you would submit under this prong that because of the growth in technology, there must be a grant of legal personhood to artificial intelligence. With the permission of your lordships, I would now like to move on to my first prong of argumentation, that there is a benefit or an interest which will accrue from the grant of legal personhood to alpha real, the artificial intelligence. Much obliged, your lordships. Your lordships, alpha real, the artificial intelligence, clearly using its randomized feature, has created something original, that is fiction flow. And this interest, that being the authorship rights, must be protected through the grant of legal personality. Your lordships, furthermore, this benefit of economic dividends or economic profits which are being generated through the circulation of fiction flow and its regular usage needs to be protected. And the recognition for the authorship of fiction flow can only be protected when legal personality is accorded to alpha real, the artificial intelligence.
I have a question.
Yes, your lordship.
I come to the legal personality.
Yes, your lordship.
You just said alpha real AI creation is original.
Yes, your lordship.
Explain what is the originality.
Your lordships, in this case, when we are stating originality before this court, we are using the test of the modicum of creativity which has been laid down by this Honorable Supreme Court in the case of EBC versus DB Moda. And there are two-pronged tests. I will be dealing with that in detail in my issue 2, but if your lordships like, I would deal with
Okay, we'll go to issue 2 and I'll listen to that.
all right, your lordships. But just to reiterate, we will be proving under the modicum of creativity test.
We will go for that. We'll save our time.
All right, your lordships. Your lordships, if I may be permitted to move on to my second prong of argumentation, that there is a gap within the law which needs to be fixed, and this can be done through the grant of legal personhood to the artificial intelligence.
Can this court grant legality to AI? Is this a legislative function or is it a judicial function?
Your lordships, in this situation, we are requesting a grant of legal personhood, your lordships.
How can this court grant legal personhood? Have you looked at the recent EU AI Act? Have you looked at the recent generative law on artificial intelligence that China has implemented on 15th of August 2023?
Yes, your
Have you
lordships.
looked at the New York law? None of these three laws have talked about the legality of AI. So
Yes, your lordships.
how are you coming forward to this court and asking for this court to declare the legal status of AI?
Which country has so far identified this non-human, a machine, an algorithm?
Yes, your lordship. Your lordship, so there has been one case of Sophia in Saudi Arabia wherein they have given citizenship to an AI humanoid robot. However, if you're satisfied with that answer, your lordships, I would like to...
Okay. Go ahead.
Apologies, your
Yes, we are aware of Sophia.
Your lordships, to answer your question, the reason that we have approached this court to give the deeming fiction of legal personhood to the artificial intelligence is because this court has done it again and again when granting legal personhood to different entities and inanimate objects. To reiterate the analogies that I was drawing, in the case of companies, there was a grant of legal personhood. In the case of religious idols or deities, there was a grant of legal personhood. And when it came to giving this deeming fiction, it was also given to trees, rivers, and in certain cases, some natural beings, your lordship. So that's why, using these analogies, we have approached this court to give this deeming fiction of legal personhood to the artificial intelligence.
Yeah, great. Artificial intelligence is creating something.
Yes, your lordship.
It's creating deepfakes, it's creating new content. You may call it original.
Yes, sir.
Okay. There are arguments. I'm not going to that.
Yes, your lordship.
But the legal personhood granted to river, tree, building, are these legal persons, so-called legal persons or juristic persons, writing like an AI?
Yes, your lordship.
And you from which law school?
You're not supposed to
I'm
know
not
that.
supposed. I'm not supposed to state it, your lordship.
So sorry.
Till post-
Let us say,
There are
let us say
Apologies.
you're standing in this IILM.
Yes, your lordship.
It is a legal person.
Yes, your lordship.
IILM is a legal person. Sorry. And it's a juristic person.
Yes, your
The
lordship.
professors here, dean here, they are writing the reports, writing articles, annual reports.
Yes, your lordship.
Legal person itself doesn't write.
Yes, your lordship.
So how can you say that AI's legal person should be comparable to the non-human with something no life.
Yes.
They are not creating anything. Not tree creates something, not river creates something. At least AI is creating.
Yes,
So
sir.
originality will come later.
Yes, Your Lordships. But to give a brief, Your Lordships, the reason that we are seeking legal personhood is because we cannot give the deeming nature of natural person to an artificial intelligence. Therefore, we are trying to create a sort of negotiation or a middle ground with the law, wherein we are giving this deeming fiction of legal personhood to the artificial intelligence.
We got it. You have 10 minutes left to go for the other issues.
Yes, Your Lordships. Your Lordships, coming back to my second prong of argumentation, that there is a gap within the law within which the courts have recognized that this deeming personality of legal personhood would help rectify. Your Lordships, if I may ask you to refer to the petitioner's memo.
What page are you referring to?
Your Lordships, page number 6, para 26. And also as well as citation number 22, Your Lordships, wherein we have cited the Parliamentary Standing Committee's report stating that the Copyright Act of 1957 of the Republic of Zindis has a clear lacuna within it wherein it does not recognize the authorship for artificial intelligence. Therefore, Your Lordships, it's page number 6, para 20. Your Lordships, proceeding with my argument, since there has been a clear recognition that there has been a gap within the law, we therefore request that this court grant limited personhood to the artificial intelligence so that it may go on further to apply for authorship under the Copyright Act. Lordships, can I proceed with my argument?
And are you aware of the press release of the government of India recently, copyright and AI issues?
Yes, Your Lordships.
What does it say?
Your Lordships, I don't have it currently with me.
You must have read it.
Your Lordships, only in passing. Apologies for that, Your Lordships. But the reason that we are going back to this Parliamentary Standing Committee report is because they have recognized that authorship is not given.
Parliamentary Standing Committee report is not binding on the government. I put many reports in the dustbin.
Yes, Your Lordships. In this case, we are only presenting it for mere persuasive value and
It all depends on the policy decision taken by the government.
Yes,
Government
sir.
can't be done by the Parliamentary Standing Committee recommendation.
Yes, Your Lordships. The reason that we are stating this report is so that we can show that there is actually a glaring gap within the law which has already been recognized.
Yeah, please, next.
Your Lordships, proceeding with my next argument that the entity is clearly identifiable. In this situation, the artificial intelligence has a source code through which the artificial intelligence has been created, and therefore the artificial intelligence is clearly identifiable, drawing an analogy again to religious idols or to companies, wherein even though the deeming fiction has been given to entities, they are clearly identifiable. In a similar way, the artificial intelligence itself is identifiable due to its source code. Your Lord,
Today, artificial intelligence is more like a black box.
pardon me, Your Lordship.
Today, artificial intelligence is more like a black box.
Yes, Your Lordships.
And even the creators of AI cannot really say how it's going to behave.
Yes, Your
So
Lordship.
in a scenario like this, how does a common litigant or a common layman determine which area of the computer algorithm will be AI and which will be cognitive intelligence?
Your Lordships, in this situation, when we are dealing with alpha real, the artificial intelligence, I would like to restrict my submissions only to alpha real, the artificial intelligence. It using real neural networks and natural language processing. We would like to submit that it forms a representative nature of itself. The reason that we are asking for a legal personhood or the deeming fiction of legal personhood, albeit for a very limited reason for application of authorship, the decision of whether liability can be imposed on it or not can be a future decision which the courts rule upon or which the legislative department takes a decision upon. However, in this situation, because of this lacuna which exists, we are applying for legal personhood, Your Lordships.
Okay, one thing, Mr. Ramurthy created this, who is the creator of this algorithm, AI algorithm?
Your Lordships, in this situation, the very specific code writer, the facts are silent on. So therefore, we believe that it is Mr. Ramurthy and Newtech
Okay,
Limited.
let's take face value Ramurthy created.
Yes, Your Lordship.
Does Ramurthy explain you? Did he explain you what is the technology, how it works actually?
Your Lordships, the facts in this case only limit us to the idea that artificial intelligence usually.
This has simply said artificial intelligence, it has created buoyant defense. It didn't explain how technology works.
Your
How it
Lordship.
how it retrieves the document, how it classifies it, how it categorizes it, what is tokenization, learning.
Your
These
Lord-
technologies, you know,
Your Lordships, unfortunately.
AI learning, or how patterns are created, data sets are created, and finally how output comes out.
Your Lordships, in this facts, the facts are silent upon how the artificial
Basic
intelligence
text
exactly.
and data mining takes place. The natural language
Yes.
processing you
Yes.
mentioning.
Yes, Your
That
Lordship.
is the core algorithm which all LLM model function with,
Yes.
like ChatGPT and all.
Yes, Your
that.
Lordships. In this
Okay,
case,
okay. If you are not aware, don't waste time. Go ahead.
Your Lordships, if you might just refer to the proposition wherein I can just clarify that doubt as to the limited knowledge that we have about the alpha.
Okay, understood. You save your time and concentrate on other issues.
Alright, Your Lordships. Your Lordships, finally I would like to submit before this court that the deeming fiction of legal personhood has been provided in cases wherein there has been a historical change of circumstances. In this situation, the Copyright Act itself never considered that there might be a creator such as artificial intelligence and its authorship needs to be granted, or its rights need to be protected, or it needs to be recognized under the Copyright Act, or its original work needs to be protected. Therefore, we present before this court, or we pray before this court, that there must be a limited legal personhood which is provided to the artificial intelligence alpha real, so that it may apply for authorship under the Copyright Act. If your Lordships are satisfied with my submissions, I would now like to proceed with my issue 2, that is whether alpha real the artificial intelligence may apply for authorship under the Copyright Act. Your Lordships, if you may refer to the Copyright Act section 2D6. Just apologies.
Section 2.
2D6.
Okay.
Your Lordships, under 2D6, it states that author means in relation to any literary, dramatic, musical, or artistic work which is computer generated, the person who causes the work to be created. Your Lordships, in this situation, there is a clear lacuna which again exists because it only recognizes the computer generated work to be as an assistive tool and not the tool which is actually creating this original content. Therefore, there's a clear lacuna which exists and only the person can be granted authorship. Therefore, we state before this court that there must be a broadened definition of the person itself rather than only natural persons, linking it to my first argument that legal persons must also be considered under this definition so that they may apply for authorship under this clause, Your Lordships.
Answer the question.
Yes,
You have a smartphone.
Yes, Your Lordship.
After this event, you take a selfie with two judges.
Yes, Your Lordship.
Okay. Author is yourself or your mobile telephone.
Your Lordship, in this case, I would be the author, Your
Alright.
Lordship.
There is a lacuna. I said you simply click the button and there is a gap in the who is the author for the photograph. That says the itself says you need person who clicks the button.
Yes, Your Lordship.
There is a gap.
Your Lordship.
Actually, it says clicks and the entire work is done.
Yes,
And the managing the light, managing things, everything, creativity, expression is a machine. You
Yes,
should
Your
go to your iPhone or whatever instrument you have. There is a gap.
Yes, Your Lordship.
So how do you argue this thing? How come you are taking copyright? There is a gap. It should go to the machine also.
Yes, Your Lordship. In this situation, what we are arguing is that when we take a picture, Your Lordship, there is a certain amount of human interaction or a certain amount of human input which is there.
Because everything automatic, you need not adjust. It adjusts everything. Light, shade, everything. It
Yes,
creates and gives you.
But there is a large interaction. There's a large part of human interaction which takes place, Your Lordship, and the smartphone merely forms as an assistive tool in taking the picture. What we are contending.
I don't want to argue further. Go to the next issue.
Your Lordship, just to wrap up that one final thread of argumentation before I proceed. Your Lordships, whereas the artificial intelligence alpha real has generated this album fiction flow through its randomized feature, there hasn't been that large amount of human interaction which has taken place. The alpha real has created the lyrics, has created the flow, has created the paragraphs by itself without any human interaction, with information which is available on the public domain, Your Lordships. Your Lordships, proceeding to my second prong of argument, that Alpha Real could be considered to be an author under the Copyright Act. The test which has been laid down in the case of EPC versus DB Modak is that of the modicum of creativity. Your Lordships, the modicum of creativity lays down a two-pronged test. Number one, application of skill. Number two, application of judgment. And both of this must lead to the creation of original work. Your Lordships, we contend before this court that Alpha Real has done both of them, because it has scanned through data, it has taken inspiration from information which is already available in the public domain. I would again like to draw an analogy to a human artist who might have done the exact same thing, wherein they have taken inspiration or they have taken certain amount of artistic freedom from information which is already available in the public domain and have created their original works. Alpha Real has done the exact same thing, wherein it has taken inspiration from information again available in the public domain and has used it for its own purposes to create lyrics and to create this album fiction flow. Your Lordships, I would like to again present before this court that, apologies Your Lordships, that it has used its skill and judgment clearly, because it had to apply its skill and judgment to know which lyrics to place where, which paragraph to place where, what composition to use, and what lyrical flow to use to create this brand new album, known as fiction flow. Your Lordships, if you are satisfied with that kind of argumentation, I would now like to proceed to my... Yes, Your Lordship.
Have you heard the case Naruto versus
Yes, Your
Peter
Lordship.
Slater?
Yes, Your Lordship.
What
It's
is
about
that
a
decision?
chimpanzee.
Of course, a matter was not decided by the Supreme Court of US,
Yes, Your
because there was out of court settlement.
Yes, Your
But at least the district court and the court of appeal
Yes.
went in favor of Peter Slater, the photographer, not the Naruto on behalf of the data. Why?
Your Lordships, because in this situation, I would not like to draw a distinction between that case and this case, Your Lordships. Because in
Naruto, the macaque monkey is a human.
no, Your Lordship.
Is a person.
No, Your Lordship.
Number one. Number two. The second question. John Grisham
Yes, Your Lordship.
and other authors and others, Guild of America, including the New York Times, filed a case against OpenAI, Google, Microsoft,
Yes, Your Lordship.
and other LLM models or generative AI model creators, saying that without consent and compensation, these people are scrapping and using our content available in the public domain. And even Getty Images said, Getty Images, the 60 billion text, photo, data which has been scrapped without consent and compensation.
Yes,
Is infringement of copyright what these all AIs are doing. No original work is created, simply copying
Yes,
from the pre-existing data. No, nothing new data. It simply learns how this is written, how paintings have been done, how photographs have been taken,
Yes,
come up with a new thing out of that.
Yes, Your Lordship.
It can't walk into Avandugal Jika study room where he is not using any various reasons, because he knows that he is a hacker, expert giving judgments, helping the people against hacking. He is not using any electronic equipment so that his opponent should not hack his arguments. He is writing down.
Yes,
Do
Your
you
Lordship.
think that your AI will walk into the study room and read and everything and come with a report saying that it's original? It's not possible.
Yes, Your Lordship.
Okay. So how do you say that it is original? How do you say that it is a person? Tell me.
Your Lordships, before I answer, might I seek a 120-second extension from Your Lordship so that I can answer your
please,
question
please,
as well as wrap up my
please.
submission. Much obliged, Your Lordships. In this situation, Your Lordship, in all of those cases, in the case of John Grisham or Getty Images, there was a copyrightable material which was taken by the AI. In this situation, because of the claim of the
Copyright exists in that?
Your Lordship,
The AI is taken the content. Copyright exists in that, or it is a public domain material?
Your Lordship, in that situation, it was the claim of John Grisham and Getty Images was that the artificial intelligence has taken copyrightable material.
But in this specific instance, in this specific case, wherein our learned respondents are claiming that we've used MC Bars' personality rights or we've used his copyrightable material, I would like to direct you to the clarification.
Copyrightable material or where copyright exists in that?
Your Lordships, what I'm saying is
Because you once you are created, you are arguing that it is copyrightable material, it's original.
Yes, Your
But
Lordship.
what you are creating from existing copyrighted material, where copyright exists, copyright has not exhausted. It's not in the public domain.
Yes, Your Lordships, I would like to
Because
answer this.
authors are alive, even the authors were 60 years ago.
Yes, Your Lordship. I would like to answer this in a two-pronged fashion, Your Lordships. One is with regards to the 60 years post the death of the author. In this situation, MC Bars, if you may refer to the clarifications which have been on the moot proposition, issue on question number 4 about MC Bars having the copyright on his music. MC Bars did not have a copyright on his music, Your Lordships, and therefore there was no authorship which was provided to MC Bars. Furthermore, Your Lordship, the second prong of my answer would be that artificial intelligence has merely taken inspiration from the information which is available in public domain. It has not taken this copyrighted material or rewritten anything. It has generated something which is original by itself. It has merely taken inspiration the same way a human artist might take inspiration from music or from material which might already be present in the public domain, Your Lordships.
You have finished your answer?
Yes, Your Lord.
Yeah.
I have one.
Yeah, if you have finished, I just make one statement.
Yes, Your Lord.
Petronius AI, it has done survey on the work of LLM models like ChatGPT, OpenAI, and the Google's Gemini and Bard, and the Microsoft Bing and other existing things, and the Copilot and all.
Yes, Your Lord.
They said clearly survey, it's a survey done by computer data scientists, experts in creating AI algorithm. What they said that everything is copied and pasted, paraphrased, nothing is original. This is one. Okay. Next comes, let us say that assume that your AI is recognized as a legal person.
Yes, Your Lordships.
You're not asking for recognized as a natural person,
Yes, Your Lordships.
only legal person.
That was my second prong of argumentation.
And then how much term of copyright has to be given to the legal person?
Your Lordships, in this situation, that was
Because
my
person is entire life plus 60 years.
Yes,
ये
Your
तो
Lordship.
मरेगा नहीं,
Yes, Your Lordships.
जिंदा है, हाँ, तो plus 60 तो आएगा ही नहीं, तो how much you want? No.
Your Lordships, in this scenario, what we are requesting before the court is because, again, since my time is up, just a 30-second extension and
Then
then
I'm taking 10, don't.
apologies, Your Lordships. Just 30 seconds and then I'll hand it over to my co-counsel, Your Lordships.
Then let him explain your.
No. He's the co-counsel, Your Lordships. He'll be dealing with the.
Let him explain whatever.
No, Your Lordships, if it's fine, he can.
Okay,
just
please.
30 seconds, Your
Okay.
Lordship. Your Lordships, in this case, what we are requesting before this court is that the term person, which has been determined as to be only a natural person who can apply for an authorship, it must be expanded to include legal persons as well, Your Lordship, so that the artificial intelligence may apply for an authorship in this situation. So, with the broadening of the definition, Alpha Real may be able to apply for an authorship if it meets the test of modicum of creativity, Your Lordships, which it clearly does in this case. If Your Lordships are satisfied, I would like
Now,
to.
do you think that copyright registration is a mandatory or voluntary?
It's voluntary, Your Lordships.
Voluntary. Copyright, I was registered for 6.5 years.
Yes,
Longest term anyone enjoyed visiting before.
Yes, Your Lordship.
So, have you seen the application form, copyright application form?
Unfortunately, not the exact
Yeah.
copyright.
If this IILM applies for the copyright of the report prepared by Professor Vani,
Yes, sir.
it fills up the form as a owner
Yes, Your Lordship.
because Professor Vani gets a salary.
Yes, Your
But
Lordship.
still, author, it will show him as an author.
Yes, Your
Because
Lordship.
the ownership is with him, the copyright goes to IILM.
Yes, Your
So,
Lordship.
who is the person?
Your Lordships, in this situation, the owner is IILM, but Professor Vani is the author. That's something similar that we are seeking before this court, Your Lordship, wherein artificial intelligence should, because again, the term of person who can apply for authorship has been narrowly interpreted to only be a natural person, Your Lordships. If there is an extension or an expanding definition which is implied, wherein legal persons can also apply for authorship, in that situation, the artificial intelligence may be capable of applying for authorship under the Copyright Act.
You want a co-authorship
Your Lordships, we are amenable to a co-authorship as well, Your
or
Lordships.
a single authorship, independent authorship?
Your Lordships, it's within the discretion of this court. What the prayer that we are seeking before this court is for sole authorship. However, if the court is amenable to under their discretion to provide us with co-authorship, that is also something that we are amenable to.
Okay, please.
Much obliged, Your Lordships. Just one last statement and then I'll hand it over. Your Lordships, if you're satisfied with all the answers that I've provided, I would like to reiterate my two prayers and two reliefs that I'm seeking before this court. Number one, that limited legal personhood be awarded to artificial intelligence so that it may apply for authorship under the Copyright Act. And number two, that definition of person be expanded to include legal persons as well. In pursuance to it, Alpha Real, the artificial intelligence, may be able to apply for authorship. With that, I would like to conclude my submissions. Much obliged, Your Lordships.
Greetings, Your Lordships. I would like to seek permission to approach the press. Good afternoon, Your Lordships. My co-counsel has already dealt with issues 1 and 2, and I shall be dealing with issues 3 and 4. Issue 3, Your Lordships, is regarding the fundamental right violation of MC Bars the rapper and whether the same can be enforced against Mr. Ratan Murthy in a private capacity. While issue 4, Your Lordships, is regarding the IT rules of 2023 and whether the same is within the bias of A, the Constitution of India, and B, the IT Act in itself. Your Lordships, with your permission, I'd like to move on to my detailed submissions. Your Lordships, much obliged. Firstly, I would like to address issue 3, which is regarding the violation of fundamental rights of MC Bars as a result of the music album produced, which is Fiction Flow, by the generative AI, and whether the same can be enforced against Mr. Ratan Murthy representing Newton. Your Lordships, I shall deal with this argument in 3 prongs. My first prong, Your Lordships, shall be that fundamental rights cannot be horizontally applicable and cannot be universally applicable to extend beyond state actors to now encompass also non-state actors and private bodies. Further, Your Lordships, I shall argue that even in arguendo, if this honourable court deems it fit that the fundamental rights be horizontally applicable and universally applicable to non-state actors, even then, Your Lordships, my argument would be that there in fact exists no fundamental right violation in the first place. Thirdly, Your Lordships, I shall also argue that even if in arguendo the honourable court declares that there is in fact a fundamental right violation of MC Bars, the same cannot be used to curb the exercise of free speech of and expression of Mr. Ratan Murthy, as the album Fiction Flow is the exercise of free speech and expression, Your Lordship. Moving on to my detailed submission regarding the first prong, Your Lordships. The first submission is that the Supreme Court in the past has been very circumspect in giving a direct horizontal application to fundamental rights, especially those flowing from Article 19, 21 and Article 14, to only grant it to state actors, Your Lordships. Your Lordships, allowing citizens to bring private issues to writ courts would blur the distinction between a civil right jurisprudence and fundamental right jurisprudence, and would in fact take away from the symbolic significance of fundamental right jurisprudence in itself, Your Lordship. Courts have ruled that fundamental rights may only extend to non-state actors or private persons in case those private persons or non-state actors perform a public function. Your Lordship, the submission in this regard is that Mr. Ratan Murthy is primarily not a state actor. Secondly, he does not perform a public function because he is in the business of producing music for commercial gain and commercial use, and the same cannot be equated to a public function. Your Lordships, the submission therefore in this regard is that since there exist two private parties, there exist alternative remedies that MC Bars could have sought, which do not relate to fundamental right or a constitutional code, and therefore, Your Lordships, the humble submission is that the claim of MC Bars that his fundamental rights are violated is not maintainable against Mr. Ratan Murthy, since he is a private party. If your lordships are satisfied with that submission,
What is, he is a private
he is a private party, your lordships.
party,
If your lordships are satisfied with that submission, your lordships,
but he is a person,
Mr. Ratan Murthy, yes, your lordship.
he is a national person, he is a citizen.
Yes, your lordship.
Okay. Still, no fundamental rights can be granted.
Your lordship, the submission is that MC Bars, whose music was sampled by the AI, cannot enforce his fundamental rights of right to livelihood or right to privacy against a non-state actor. Because fundamental rights, in theory and traditionally, have only been applied when a state actor does some wrong. This is because when there is a dispute between two private parties, there exist alternative remedies available to the private party to move the civil court. And therefore,
Can you tell us whether the state was a party whose position is below or here?
the lordship, the state is in fact a party, but on the respondent side, against A, whether there is legal personhood that can be granted, B, whether there can authorship can be granted, and C, whether the bias of the IT rules which was imposed by the state is within the bias of the constitution. The state, your lordships, is not a party in the private dispute between Mr. Ratan Murthy on one side and Mr. MC Bars on the other, which is the issue I'm dealing with right now. If there is no further clarification in lordships, I may proceed to my second prong of argumentation. The lordships, secondly, it is argued that even if this court deems it fit to award a horizontal application of fundamental rights to now include to non-state actors and to private parties, I shall be arguing that there in fact exists no violation of fundamental rights in the first place. Your lordships, I shall be invoking two specific rights that are enshrined under Article 21, which is the right to privacy and the right to livelihood. Your lordships, I shall be arguing that there in fact does not exist a breach of MC Bars' right to privacy or right to livelihood. The humble submission in this regard, in regard to right to privacy, your lordships, is that artificial AI or alpha real in general sources its information from a wide-ranging, publicly available set of records. Therefore, your lordships, as there does not in fact, it does not in fact take the voice recording or sampling of MC Bars from a private source that is private to MC Bars himself, but in fact from a public source. Therefore, your lordship, there in fact does not happen to be a violation of MC Bars' right to privacy. This is the first prong of my right to privacy argument, your lordships. Further, your lordships, this can also not amount to be in violation of right to be let alone, which was held to be a facet of right to privacy in the famous case Puttaswamy versus Union of India judgment. Because, your lordship, it does not have the effect of putting into the mouth of MC Bars some words that he did not wish to utter. This is because, your lordship, what Alpha Real does is again generate completely new work and completely original work, which is completely separate from anything MC Bars has previously produced. Your lordships, this would therefore entail that no person who would attribute the lyrics in which are contained in Fiction Flow, the album produced by Alpha Real, to be attributable back to MC Bars himself, because it is the Alpha Real album does not solely depend on the voice of MC Bars, but an array of different technological inputs and differently sourced musical components to produce a music album. Therefore, it cannot solely be attributed to by any reasonable person back to MC Bars. Therefore, it does not have the effect of putting words into the mouth of MC Bars himself, because no reasonable person would attribute the lyrics uttered by Alpha Real, the AI, back to MC Bars himself.
But the voice samples of MC Bars used by the algorithm for the purposes of generating its output?
Among other samples, yes, Your Lordship.
Okay, so how do you address the issue of absence or otherwise of originality?
Your Lordships, it is submitted that there in fact does exist a facet of originality even in this creation. This is because, Your Lordships, there is no complete replication or even partial replication of any of the previously existing musical records that have existed on the platform, and this in fact is a completely new production of new lyrics, new beats, new tones, and new cadence to the music. This, Your Lordships, does in fact feed into the fact that there exists a scope of originality that can be awarded even to the music album produced by Alpha Real himself.
you're familiar with the Delhi High Court judgments and orders on personality rights?
Yes, Your Lordship.
So how about the voice samples being an integral manifestation of personality rights? So what is the way forward?
I completely concede, Your Lordship, that there exists a bundle of personality rights that every person, especially a celebrity, enjoys, and the voice of a person or a celebrity does in fact is in fact a very important component of the bundle of personality rights. However, Your Lordship, the contention in this regard is there exists no replication or absolute imitation of the voice of MC Bars as compared to the lyrics or the music produced by artificial intelligence, that is Alpha Real. Your Lordship, I can draw a distinction between the Delhi High Court rulings in, let's say, Amitabh Bachchan, where there was a total imitation of Amitabh Bachchan's voice. Therefore, it was held to be a breach of his personality rights. However, the same cannot be imported in this regard, simply because there is not a complete export and import of voice. It has gone through a certain level of technological input, and other open world source inputs have been put through.
Amitabh Bachchan case is very old. This year only. Anil Kapoor case.
Yes, Your Lordship.
You tell me what did Delhi High Court decided on Anil Kapoor?
Your Lordship, in that case it was held that the imitation of Anil Kapoor, his voice, his persona, against, without his consent, is a violation. Granted, Your Lordship, but again, this brings me back to my contention, my first contention, that this is not a blanket imitation. There, it has gone through a certain process which leads to there being original content on behalf of Alpha Real himself.
If not a blanket imitation, why did A.R. Rahman took permission of the dead person's family to create a deepfake video and so on?
The Lordships, I'm not aware very narrowly.
Why did he take permission?
Your Lordship, that is up to his agency, but there exists no binding.
Ethics
Yes, Your
is
Lordship.
decided by one person, ethics is not decided by one person, differs from person to person. And then tell you, and you were saying that, what is that, the fundamental rights under Constitution, not enforceable against
Private
persons.
parties.
No?
Yes, Your Lordship. I am aware.
Are you aware of January
Yes, Your
2023 5-bench Supreme Court
Indeed, Your
judgment?
Lordship.
Only my friend Justice Nagaratna opposed it.
Indeed, Your Lordship.
Subramaniam, written by Subramaniam,
Indeed,
Nahir,
Your Lordship.
it is extendable.
Indeed, Your Lordships. And
It
I
is
shall.
extendable. It's a 4+1 judgment. It's extendable.
Indeed.
Tell me how you
Indeed, Your Lordships. And
go against that
that is a
judgment.
very pertinent observation.
You know, it is an apex court judgment.
Indeed, Your Lordships, and it is a very pertinent observation which helps me build my case further. Your Lordships, in Kaushal Kishore, firstly, I would like to build on the dissent that was published by Justice Nagaratna. And further, I would say that Kaushal Kishore, in its holding,
So you want that Nagaratra is implementable, not before.
Your Lordships, the submission is that in the case of State of Kaushal Kishore versus Uttar Pradesh of 2023, the Honorable Supreme Court went against the grain of the law that has been upheld in a line of judicial interpretations of rights flowing from Article 19 and 21, which have all been constitutional bench cases, to now hold that there is a universal applicability of fundamental rights flowing from 19 and 21. The humble submission in this regard, Your Lordships, is that this is not the correct reading of the law and deserves a review, because, Your Lordships, there exists a distinction.
You mean the 4:1 judgment is not correct reading?
Your Lordships, the submission is that it goes against previous constitutional bench judgments.
Obviously. Even as a policy maker, I bring out legislation putting even apex court judgment in the dustbin. We change the law. If that is not a violation of the Constitution, Article 30 and Article 32, even Supreme Court said whatever the new amendment has been done by the legislation is valid. It's not autonomous.
Indeed,
So how do we say that 4:1 is against the law?
Indeed, Your Lordships, but the fact again remains that in cases like Telecommunication versus Union of India and Zoroastrian Cooperative Housing Society, all of these being constitutional bench cases, it was again categorically held that rights flowing from Article 21 do not have a horizontal implication. Now,
That is an example of son judge is opposing father's judgment. I don't want to take the name, you all aware.
indeed, your lordship.
Is that a new law?
Indeed, your
Is
lordship.
that father, I respect my father, but the law is different.
Indeed, your lordship. But the fact of the law is that when there exists a constitutional bench judgment proceeding over another constitutional bench of the same number.
Will not waste time. You spend your energy on other issue. Anything.
All right, your lordship. Indeed. Your lordship. Secondly, I'd like to come to the right to livelihood prong of MC Bars himself. Your lordship, there may be an argument on behalf of my learned counsel that there exists a violation of right to livelihood as enshrined under Article 21 of the Constitution. Your lordships, in this regard, the humble submission is that in no way is Alpha Real Fire producing the musical album Fiction Flow impinging on MC Bars' right to livelihood. Your lordships, this is because there is no attack on his artistic integrity, because there is a very clear distinction drawn by Alpha Real the AI itself. Excuse me, your lordship. Yeah, by Alpha Real the AI itself to say that this is a complete AI generation, and it cannot be equated to a human or human standards of music. Your lordships, I would like to draw your attention to apologies, your lordship. Your lordships, I would like to draw your attention to paragraph 11 enshrined in page 4 of the Moot proposition, your lordship, where it was held, where it states that UTech decided to elevate the AI landscape in India further by deciding to release the first Indian musical album created entirely by an AI plugin. Your lordships, the humble submission therefore flowing from this is that at the very outset, the album that is being produced is publicized and is well known as a wholly AI generated album. Therefore, it cannot be equated or conflated with a wholly human generated album, and therefore it does not impinge on either the originality or the right to livelihood or the artistic integrity of MC Bars himself, because nowhere does NewTech publish or publicize their album to be similar or to pass off as a work produced by MC Bars himself.
Thank you.
Your lordships, I would further like to move on to my third prong, if it is fine, which is that, your lordships, the Alpha Real AI tool and Fiction Flow in general is an exercise of the petitioner's or Mr. Ratan Murthy's right to free speech and expression enshrined under Article 19(1)(a). And even if the Honorable Bench decides to hold that there in fact is a fundamental right violation of right to privacy or right to livelihood of Mr. MC Bars, the same cannot be used to impose a restriction on free speech and expression of Mr. Ratan Murthy. Your lordship, the court has, in a line of judgments and a catena of judgments, held that reasonable restrictions under Article 19(1)(a) can only be imposed if there is a proximate nexus to any of the grounds enshrined under Article 19(2). Your lordship, the humble submission is that no rights flowing from right to privacy or right to livelihood are enshrined under Article 19(2) of the Constitution, and therefore a restriction on the exercise of free speech and expression as enshrined under 19(1)(a) of the Constitution cannot be placed, because there is no proximate nexus between the restriction imposed and any ground listed under 19(2) of the Constitution. Your lordships, further I'd like to state that even if this court does deem to hold that there is a violation of right to privacy, the same, as I've reinstated, cannot be held to curb free speech under 19(1)(a). Your lordships, therefore, to sum up issue 3.
So, Mr. Counsel, you are saying that we should allow free speech which goes ahead and murders privacy. Is that your proposition?
Your lordships, your lordship, this is a very tricky proposition of balancing two fundamental rights. One,
your argument is on one side of the spectrum only.
Your lordships, I concede that this is a very tricky proposition of balancing two different citizens' fundamental rights. On one side, it is NewTech and Ratan Murthy's fundamental right to free speech and expression. On the other, if this court does deem that there is a privacy or a livelihood violation, there exists Article 21 rights that are enshrined in favor of MC Bars himself. Your lordship, the courts previously have dealt with such an issue where two rights are being balanced against each other. May I continue? Yeah, so the courts previously have in fact dealt with such an issue where there is a right on one hand of one individual which is a fundamental right, and a fundamental right on the other hand of another individual. For example, your lordship, in the landmark Aadhaar judgment that is reported as case Puttaswamy versus Union of India of 2018, the proposition before the court was whether or was how to balance the right to privacy of individuals on the one hand and right to food of individuals on the other hand. This is because the Aadhaar Act, while it was alleged was infringing upon the privacy of individuals, the government had argued that there exists a right to food of individuals, and the same is being.
Please go ahead.
Yeah, so as I was saying, in case Puttaswamy versus Union of India 2, the Aadhaar judgment, the court dealt with the issue of, on the one hand, balancing between right to privacy flowing under 21 and on the other hand, right to food. Because the facts of the case were such, your lordship, that the Aadhaar Act, it was alleged, infringed on the right to privacy of the citizens, while the government argued that the Aadhaar Act has been put in place to ensure food security, and right to food is also a right enshrined under the Constitution. So, your lordship, the court went on to hold that we cannot have this balancing between two fundamental rights. So, in such a case, we must harmoniously interpret these two rights to read down one right in favor of the other. So, your lordship, the court held in this case that as the right to privacy violation was minimal, even if it was there, it was minimal, and right to food was outrightly being addressed by the Aadhaar judgment or by the Aadhaar Act in general. We must read down the right to privacy to circumscribe it with the right to food that exists on every citizen's behalf, your lordship. Your lordships, the same can be imported in this case also, because as I have vehemently argued, there is no prima facie right to privacy violation. A, because it is being sourced, his voice is being sourced by public sources, and B, you don't infringe on any of his original content. Therefore, even if there is a case for right to privacy, it is very contentious. On the other hand, your lordships, curbing down right to free speech is very prima facie on the face of it, a violation of free speech and expression, and that too not one that has a nexus with any of the grounds related under 19(2) of the Constitution. Therefore, your lordships, my humble submission is that even if there is a privacy violation, the same be read down to be circumscribed by the petitioner's right to free speech and expression, so he can go on to exercise the same right, your lordship.
Can you come to your last argument?
Your lordships, my next argument, with this I conclude my arguments related to fundamental right enforceability. My next argument, your lordships, is regarding issue 4, which has been framed as whether the IT Act, the IT rules of 2023 are ultra vires to the Constitution and the IT Act of 2000 in general. Your lordships, in this regard, I would like to
come to section 81 of the Information Technology Act. In read it says the provisions of the Information Technology Act 2000 shall prevail over anything inconsistent therewith, contained in any other law for the time being enforced.
Indeed, your lordship.
Please read that in section 87, 1 and 87.2 of the IT Act. In this context, since the power is given to the legislature, on what grounds are they arguing that the rules are
Your lordships, my first ground of argument is that they are unconstitutional in nature because they blatantly violate two rights enshrined under Part 3 of the Indian Constitution, that is right to free speech and expression again, as enshrined under Article 19, and right to equality as enshrined under Article 14. Your lordships, with my Article 19 argument, I would like to present two prongs. First, that there exists that the imposition or the restriction that has been put on free speech does not have a proximate nexus with any of the grounds enshrined under 19(2). And my first argument flows into my second argument, that the grounds listed in the IT rules themselves, which is that of being fake, false, misleading, are very vague and overbroad. This, your lordships, results in a chilling effect on free speech, which should not be the case in any democracy which is a marketplace of ideas. Thirdly, your lordships, I shall argue that in arguendo, even if there is a nexus between the restriction and any of the grounds under 19(2), the restrictions do not meet the test of proportionality, which is the adopted test by the Supreme Court in cases like K.S. Puttaswamy and Anuradha Bhasin. Next, your lordships, I shall argue that Article 14 of the Constitution is being violated, as there does not happen to be any intelligible differentia between classifying two classes of people. And lastly, your lordships, I shall also argue that there exists manifest arbitrariness on the part of the IT rules because they violate certain principles of natural justice.
Are you familiar with the advisory of the Ministry of Electronics and Information Technology of 16th of March 2024? AI service providers, ensuring that they will have to make appropriate precautions to basically guarantee that the AI programs do not interfere in the integrity of the election process. Now, once this advisory is coming, and once the rules are saying that a fact-check unit will decide something which is fake or otherwise, if it is fake information will poison the information waterways. That means so it could prejudicially even impact the sovereignty, security, and integrity of India. In this kind of context, please address this court as to why are you saying that these rules are unconstitutional.
Completely granted, Your Lordships, that there in fact does exist a very legitimate state interest, that is that of curbing the spread of misinformation on the internet, which is, again, I reiterate, it is a very legitimate state interest that the state is pursuing. Where the constitutionality is challenged of the IT rules is in the framing of the rules themselves. Your Lordships, I'd like to bring your attention to the rules which state that any information that is deemed to be fake, false, misleading, related to the business of the central government shall be deemed to be struck down, shall be deemed to be put out by the social media intermediaries. Lordships, it is submitted that these four terms specially, fake, false, misleading, and business of central government, suffer from the vices of being vague and overbroad. Your Lordships, this has the effect of having a very chilling effect on free speech, which is because it does not define very categorically what kind of speech suffers from the vice of being misinformation and is spread with the intention of spreading misinformation, and what kind of speech is a legitimate exercise of free speech and expression. Your Lordships, I should utilize my argument by giving two examples. Your Lordships, the first example being that let us say I put a statement on the internet which says 2 plus 2 equals 6. Your Lordships, this is a very blatant piece of misinformation, and the state would be legitimate to curb this because it is misinformation and a lie. Your Lordships, this is fine and this should come under the scope of fake, false.
This does not relate to the affairs of the central government. Please give us a real example.
Surely, Your Lordships. Let us take another example, which is that Mr. Rahul Gandhi is the Prime Minister of India. Your Lordships, again, this is in the business of the central government and is clearly fake. So, Your Lordships, the fact here remains that this piece of information should be curbed on the internet. That is not the point of contention. The point of contention is that by the expansive definition of fake, false, and misleading, a certain second kind of speech or arguments can also be curtailed under and can be struck down to be misinformation, which is arguments which are statements of opinion. Let us say, Your Lordships, I tomorrow contend on any of the social media platforms that the current Chief Minister is not competent to deal with, or the current Prime Minister, as the central government is involved, the current Prime Minister is not competent to deal with foreign affairs or financial matters. Your Lordships, this is a mere statement of opinion and does not suffer from the vice of being misinformation, because in a democracy I am allowed to dissent and I am allowed to criticize the government. Your Lordships, but
in what way this example is the fake or misinformation?
Your Lordships,
This is your opinion, we agree with that.
yes, Your Lordships, but
For example, that's what the law says, rule says. It's not neither the ultra virus subordinate legislation. We in the government, we have vast experience in drafting subordinate legislation and the substantive acts. It should not go beyond the provisions of the substantive law, number one. Number two, should not be ultra virus of Article 13 of the Constitution. Simple. In one way that you say that Rahul Gandhi is incompetent or somebody is incompetent. That's your view. It's not fake. It's not misinterpretation. It's not something which has been banned in the rules. Okay. And the question comes when you have fake news. For example, fake news that recently there is a India Alliance meeting. They posted a photo of people, billions attending of a 4 years back photo. That is the fake news.
surely,
Hardly and there was a video, Rahul Gandhi's yatra, hardly 10 people following it on the road.
surely.
So if you put millions are following some fake video there, and
Surely, Your Lordships. Surely.
that is what
It is-
the rule said, because this will have impact. Actually, there may be lakhs following Rahul Gandhi.
Yes, surely a lot.
That 10 may be fake.
Surely a lot.
It's
But-
possible.
Yes,
You know,
sir.
that kind of thing government wants to discourage.
Surely a lot.
Yeah. It's not about your opinion.
Sure.
What happened? Problem in this free speech
Yes,
group in India, they go overboard and try to damage the actual criminal things happening.
Surely, Your
That's
Lordships, sometimes that is in fact the case. However, Your Lordships, again, I'd like to draw your attention back to the memorial, to the proposition, Your Lordships, and to paragraph.
Please wind up.
If I could get a 120-second extension to be
That's a
fast.
standard practice of your team, or what? Your first counsel says 120 seconds. You did. Then the other 120 did 500 seconds.
Then come to 30 seconds.
Humble apologies, Your Lordships.
I think 30 seconds from Arnav Goswami's 9 o'clock prime time show.
Please conclude in us.
Just to address very specifically the issue put out by Your Lordship, Your Lordship, I'd like to draw your attention to paragraph 14 of page 5 of the proposition, where it was said that in furtherance of the new IT rules, all of the parody videos by Mr. Ratan Murthy using PM Narayan Singh filter and plugin were taken down from the internet under the claim that they fell under category of fake news. Now, Your Lordships, I'd like to draw your attention to paragraph 30, which says that one of his most popular series of content included the usage of voice and face of the PM, Narayan Singh, for parody and satire. He often used this plugin for political commentary and comedy. Your Lordship, this is exactly my argument, that due to the vague wording that is fake, false and misleading, and due to the internalization of the fact-checking unit, as to the fact that it is comprised of central government authorities and central government employees, there exists an inherent bias against anything that may be in the realm of political commentary, and the wording of the IT rules allows the fact-checking unit to exercise this bias because they are not specific and they are vague to a certain degree. Therefore, Your Lordship, the argument is that the government tends to curb even dissent and criticisms, which are completely allowed and completely respected under Article 19(1)(a) and are in fact a very important facet of any democracy. The framing of the rules is such that it allows the government to curb down even such voices of dissent and criticism. Your Lordship.
Next.
Your Lordship, if I may conclude, although I did not have the time to put forth my Article 14 argument, I would summarize it. Your Lordships, it is further stated that it is violative of the IT rules are violative of Article 14 of the Constitution because they do not meet the test of reasonable classification and intelligible differentia. Because again, the wording of the provision is fake and misleading and fake, false, misleading, which is vague and overbroad. Therefore, Your Lordship, there is no clear chalking out between the two classifications, and there is no intelligible differentia. Further, Your Lordships, it is manifestly arbitrary because, Your Lordships, it makes the fact-checking unit a judge in its own cause due to the fact that it is internalized by the central government, Your Lordships. Lastly, Your Lordships, it is submitted that the IT rules are ultra-vires the IT Act in itself because Section 79 of the IT Act grants a safe harbor to certain social media intermediaries, basically making them immune from any of the content posted on social media by its users. Your Lordships, it was held in Shreya Singhal versus Union of India, that dealt with the IT Act, that a restriction on Section 79 is only reasonable if the same is within or if it has a proximate nexus with any of the grounds enshrined under Article 92 of the Constitution, Your Lordships. Your Lordships, as I have submitted repeatedly, there exists no such proximate nexus between any of the grounds under 92 and should therefore be struck down for A, being unconstitutional and under Article 13 of the Constitution, and B, being ultra-vires to the IT Act in itself. With this, Your Lordships, I'd like to conclude, and it was a pleasure arguing before you.
Thank you, Mr. Counsel.
Your Lordships, I'd like to state my prayer very succinctly before that. Wherefore, in the light of the issues raised, arguments advanced, reasons given, and authorities cited, it is most humbly prayed that it may be pleased to declare that Alpha Rail the AI is a legal person for a limited ambit of applying authorship under the Copyright Act, expand the definition of person under the Copyright Act, which would then allow for the first relief to be granted, that there has been no violation of any fundamental rights of MC Bars by Mr. Ratan Murthy, and the same cannot be enforced against Mr. Ratan Murthy, and D, that the information technology rules are ultra-vires to the Constitution and Republic of interest, or pass any other order or direction that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted. Thank you very much.
Permission to approach the podium, Your Lordships.
So are you also going to have the 120-second rule?
Not. May it please the court, I, along with my co-counsel, appear on behalf of the respondents, the Republic of the Government of Zindhu, and Mr. Ratan Murthy. Throughout the course of my pleadings, Your Lordships, I shall be assisting the court on the key aspects of issue number 1 and issue number 2 that emanate from the first writ petition filed by the petitioners. Your Lordships, both I shall be going over my pleadings for over 24 minutes, while my co-counsel shall be going over the pleadings with 30 minutes, and as a consequence, we reserve 6 minutes for rebuttal. With your permission, Your Lordships, I shall ask to begin my submissions.
Please.
Much obliged, Your Lordships. Your Lordships, now moving with the first issue, that is regarding the granting of legal personhood to an AI tool such as AlphaReal. Your Lordships, to further substantiate my arguments, I shall be doing them under two prongs. Firstly, Your Lordships, that there needs to be an understanding of the possibility that AI can be used as a shield to circumvent human liability. And secondly, Your Lordships, it is contended before this court that AI cannot be held accountable for criminal actions. Your Lordships, by granting AI tools legal personhood, numerous issues of accountability and the treatment of artificial entities shall arise before this court. Moving on to my first point, Your Lordships. AI tools such as AlphaReal are prone to manipulation and alteration by the human beings to fit their own needs. Your Lordships, the National Institute of Standards and Technology, one of the leading institutes in combating and making sure and researching on the issues of cybersecurity, have recently highlighted in their reports that even generative AI technologies using deep machine learning are prone to cyberware attacks, wherein, Your Lordships, even simple statements that can be easily comprehended by human beings may be used and misinterpreted by the AI tool. These attacks, Your Lordship, convolute the data inputs put in for the AI, which results in the AI misrepresenting simple instructions. Your Lordship, as an analogy, I would like to take the example of a self-driven car. Your Lordship, with a simple cyberware attack wherein data inputs and used in the RNN technology as referred to in para 8 of the Moot proposition. Your Lordship, by simply adding in different neural applications and inputs to the software used, it can make the AI interpret a stop sign as a green light, thus making the self-driven car crash into any such pedestrian. Your Lordships, under the second prong, it is contended that an AI cannot be held accountable for criminal actions. Lordships, one of the most integral qualities of a legal personality is the ability for it to be punished. It is settled principle of law that mens rea is an important prerequisite to constitute criminal liability. Since the Lordships and AI, and as claimed by the petitioners, are going in for a limited personhood, that is to say that AI does not constitute individual consciousness and intentionality, Your Lordships, they can always take the defense of the same, that they, as they do not possess individual consciousness, they can plead the defense of not being capable of doing harm or committing a crime. Your Lordship, to further elucidate this, I shall be taking the example of the deepfake problem that is plaguing the world right now. Your Lordship, if we grant an AI tool such as AlphaReal or any such AI tool legal personhood for the matter, it can and it will share equal liability, and it is the AI that is generating the deepfake. Your Lordship, in case of holding the AI accountable, how shall we punish the AI? As there exists no regulatory framework for the matter for holding AI accountable under criminal actions. Your Lordships, it is further submitted that possible solutions such as even switching off the AI or simply waiting for a new regulatory framework to be released by the legislature are not reasonable options. How shall we reform AI at the same time hold them accountable for their actions done in the capacity of a legal person?
So does that mean, Mr. Counsel, that we can continue to allow AI to mislead Indians and innocent users into believing that its hallucinated content is correct?
Lordships, I see the clarification. What would the AI misrepresent the innocent citizens?
Please.
Recently, US court imposed a $5,000 fine because judge was very nice, like my friend Pawan. Imposed only $5,000 fine on the advocate like you, who filed an affidavit written by ChatGPT. Because of AI hallucination, it created 6 fake cases with citation and ratio. So, and who is responsible for it? Simply what OpenAI and Google and Microsoft argued before the US copyright office open discussion. Just like, you buy camera, a photocopy machine, you engage AI, whatever happens, you are responsible, we are not responsible. So, what do you say for this?
Your Lordship, regarding...
So, infringement is being done, the deepfakes are being done. So, you should know the law, whether it is copyright law or IT rule, that neither the content piracy should happen, nor IT rules be violated. What do you say? So you say that you leave it to machine, and machine is doing everything. We are not responsible. The user is responsible. Tomorrow you scan and copyright material or download a copyright material content using this. Who is responsible? Machine responsible, or the person using it responsible?
Your Lordship, for the same, the person should be held responsible. As regards to the advocate who used ChatGPT to create 6 cases and deciding the ratio on its own, Your Lordship, it is further contended that the ChatGPT merely acted on the prompts entered by the lawyer itself. That is to say, the lawyer being reprimanded is indeed the right decision, where he used ChatGPT as a means to plead his case.
ChatGPT did not generate those 6 fake cases on the insistence of the lawyer. The lawyer just asked for the written submission to wait. These were fabricated and hallucinated by ChatGPT on its own. So in a scenario like this, how would you want to argue this proposition?
Yeah, have you heard the basic thing happening with the AI hallucination?
My apologies, Your Lordship.
Just like that, the person having the hallucination is not thinking that, Mahatma Gandhi is sitting here and listening to your arguments.
Your Lordship, apologies for misinterpreting the question. Regards to the answer to the above question is that AI producing hallucinogenic generations of content and as well misinterpreting the prompts of the human person, it is further adds to my case that granting AI legal personhood would lead to a lacuna, as in how can AI be held responsible for the same? Your Lordships, by engaging in such even made within a line of code and algorithms, if the AI goes beyond and produces inaccurate content, inaccurate data, which even goes within and beyond its deep machine learning capabilities, how can we entrust the legal personhood to AI if the own regulatory framework and the legal rules of this country of Zindus cannot accommodate the same? Your Lordships?
So should the courts, should the policymakers be viewed spectators? What should be done?
Absolutely not, Your Lordship. In case of the AI defecting and producing hallucinogenic operations or content for that matter, Your Lordship, I would like to refer that even generative AI models using RNN and NLP cannot go beyond what is written in their code and algorithm. For the same.
Are you aware that in February 22, NITI Aayog came out with a paper, Responsible AI, and in August they came with the second version of Responsible AI, how to implementation of the Responsible AI. Are you aware of that? Why should reply to your prompt. Is something not available on the database or cloud or the internet website?
Yes, Your Lordship. Regarding the same, as again used and argued by me, an AI model and generative AI model cannot go beyond its source code and line of algorithms that operate. Your Lordship, if it cannot go beyond the source line of code, any such hallucinogenic content released or generated by it can be attributed to the code it operates upon. And Your Lordship, if this code, if this algorithm is written by a programmer, and the programmer is in this case the part of the company or the agency that have developed the AI, they shall be held responsible for the same.
Yeah, next please.
Your Lordship. Lordship, now I shall be moving on to the second issue of the writ petition, that is regarding the granting of authorship to an AI tool such as Alpha. Your Lordship, I shall be substantiating my above arguments under three prongs again. First, that only a natural person can claim copyright protection under the Act. Secondly, that the works of the AI tools such as AlphaReal are not original under Section 13 of the Copyright Act. And lastly, Your Lordships, that the works of AlphaReal cannot be held eligible for copyright registration. Moving on with the first prong, Your Lordship. It is humbly submitted by the court that AlphaReal is not a natural person and hence cannot be granted copyright protection. As stated by the Delhi High Court and international jurisprudence across the world, juristic persons are incapable of being the author of any work under the Act. Hence, an AI tool such as AlphaReal would cease to have any such copyright protection and subsequently cannot be qualified as an author under Section 2, Clause D of the Copyright Act. Your Lordship, the Delhi High Court, in Rupendra Kashyap vs. Jeevan Publishing House Limited, held that compiling can be protected as copyright only if it is done by a natural person, that is a human being. Your Lordship, in pursuit of the same, the Central Board of Secondary Education was held not to be eligible for copyright as it is not a natural person. Similarly, Your Lordships, as further mentioned by the bench themselves, the case of Thaler or Naruto versus Slater has again been reiterated by international jurisprudence such as the US that the underlying intent behind their own Copyright Act is to encourage and protect human creativity. Your Lordship, even if AI is granted authorship under the Act, it shall pose serious risks to human creativity in the sense that AI generated creativity shall be placed on the same threshold as human creativity. In order to elucidate the same, I would like to take the example of any such artistic or literary work created by an AI tool. Your Lordship, it may take the AI tool mere minutes or even seconds to generate a highly impressionistic painting based and even write a full novel, a criminal novel, a fiction novel in a matter of minutes. Your Lordship, the same may take a human author in exercising its own creative output years to produce the same. In case, Your Lordship, it is given authorship, such works may domain and dominate the field of artistic works in the world, and that may lead to the disincentivization of human creativity. Your Lordships, I shall now move on to my second prompt, that is considering the originality of the works made by the AlphaReal. Your Lordships, I would like to contend some of the statements put in by the petition, wherein they say that the Constitution or the Copyright Act of the Republic made passed under the Republic of Zindus subscribes to the modicum of creativity test. Your Lordships, it has been established in Eastern Book Company versus D.B. Moder that the sweat of the broad doctrine and the modicum of creativity test have both been not taken as the test of originality. Rather, a middle path to the both of the threshold known as a skill and judgment test has been taken as a threshold for deciding originality. Your Lordships, the same judgment in Eastern Book Company versus D.P. Moder states that the creative work by an author should not be a product of mere labor and capital, but shall also have distinguishable flavor and style. If your Lordships could please refer to para 11 of the Moot proposition.
Page.
Your Lordship, it shall be page 4, para 11. If your Lordships are with me.
Which line?
Your Lordship, I am referring to the second and the third line. Your Lordship, it states that the album fiction flow is created by Alpha Rule, and to state the exact line, that Newtek decided to use the MC Bars plugin and effectively his voice, lyrical style and flow for this album titled Fiction Flow. Your Lordship, as the album uses the creative expression of MC Bar, such as in this case his voice and his lyrical flow and his distinguishable style, the output generated by an AI tool such as AlphaReal merely constitutes reproduction and compilation of the creative expression of MC Bars. And therefore, it contended that it shall not be offered authorship. Your Lordship, my further contention is that under section 2, clause B, subclause 6 of the Copyright Act, an author of a computer generated musical or artistic work is defined as the person who causes such work to be created. Your Lordship, all work created by an AI model includes a prompt which shall be entered upon by a human, which acts as a directing force for the final output generated. Your Lordship, it can be ascertained that it was indeed human interference that inevitably led AlphaReal to conceive of a musical album in the first place. Without the same, Your Lordship, it can be logically deduced that the AI tool AlphaReal would not have been able to come up without the use of the plugin and the human prompt. Therefore, it was indeed a natural person who caused the work to be created and not the AI itself. And hence, it does not qualify to be an author under section 2, clause D, subclause 6 of the Copyright Act. Your Lordships, now moving on to my final prompt, that is regards the issue of copyright registration. Your Lordship, in order to file for a copyright registration, it is a prerequisite that the author shall fill out Form 14 under the Copyright Act. Your Lordship, Form 14 states that the author of the work that is held to be copyrightable must fill out his address, phone number, date when the work was conceived, etc. Lordship, as the AI is an intangible, you can say, object, and it lacks individual consciousness, how is it required to fill the same form? If it is not, is it possible? How and is it possible? And at the same time, how is it in a position to get a registered copyright under its name? And it is also humbly submitted as there exists no alternative framework or form to fill in for the registration of a work by an AI. It cannot do so. Hence, Your Lordships, I humbly submit before this court that authorship shall not be granted to an AI tool such as AlphaReal under the Copyright Act. If I cannot be of further assistance to the court, I shall end my submission. And Your Lordships, as I end my submissions, I would like to point out another Your Lordships, approaching the court under Article 136 is in gross violation of the jurisdiction of this court. Therefore, Your Lordships, as I begin to end my submissions, I'd like to state the prayer for me.
Where have you stated, where is it stated in the facts that they were forced under 136?
They have not, Your Lordship, and that's precisely the case as they have contended that they have approached under 136. But Your Lordship, they have approached under Article 32 of the
Anyway, there's no restriction on this power of this court, whether to entertain under 136 or the duty.
Your Lordships, indeed, but it is frowned upon that if an alternative remedy existed in the place of the petitioners, they have not resorted to the same and gone under Article 32 of the Constitution. Your Lordships, in order to end my submissions, I state permission to state the prayer for my issues. Much obliged, Your Lordships. Your Lordships, it is submitted at in light of the aforesaid arguments and submissions. The respondent, one, that is me, most respectfully pray that this honorable court may be pleased to declare that Authorship, an AI tool, is not a legal person with legal rights and obligations. And secondly, that Authorship, an AI tool, cannot be considered as an author under the Copyright Act 1957. With this, it was a pleasure pleading before this court. Thank you.
Thank you, Mr. We have the next student.
Permission to approach the bench. Your Lordships, I am the counsel for the respondents for the second and the third petition filed before this honorable court. Your Lordships, over the course of the next 24 minutes, I will be assisting this court on the key aspect of these two writ petitions. Your Lordships, shall I begin?
Please.
Your Lordships, firstly, I would like to state that we agree with each and every aspect of the contentions raised by the petitioners in issue 3. We are in consonance with every argument raised by the petitioners because it seems to us that they have pleaded our case. Your Lordships, to clarify, the second writ petition was filed before this honorable court by the petitioner MC Baz against the respondent Mr. Ratan Murthy. Your Lordships, this is clearly stated in moot para 50, the proposition para 15 in page number 5. Are you with me, Your Lordships? Your Lordships, in para 15, in the third line, it states that MC Baz sued Mr. Ratan for the violation of his personality rights through the plugin created by Newtech. MC Baz claims that his personality rights is his fundamental rights and the same has been breached. Issue 3 is a question of violation of MC Baz's fundamental rights, which makes MC Baz the petitioner who filed the petition in front of this honorable court. Hence, Your Lordships, the petitioners have ended up pleading the case against their own client and have made this case easier for me to plead. But Your Lordships, however, in furtherance of the arguments that I have prepared, we have two broad submissions to make. Firstly, that the writ petition filed by the petitioner MC Baz is not maintainable, and secondly, the actions of the defendant are not violative of the rights under Article 21. Your Lordships, under my first submission, that is, that we contend that the writ petition filed by the petitioners is not maintainable and must be dismissed with costs immediately. As one, there is no prima facie violation of fundamental rights, and two, alternative remedies have not been exhausted by the petitioner. Your Lordships, under my first argument, I quote, that violation of a fundamental right is the sine qua non of the exercise of the rights guaranteed under Article 32. This was reiterated in Bandhuan Mukti Morcha versus the Union of India, Janata Dal versus the Union of India. Article 32 is concerned with fundamental rights and fundamental rights only. It is not concerned with breaches of law which do not involve fundamental rights directly. Your Lordships, as will be expanded by me on my second submission in the coming time, the actions of the defendant do not illegally or unlawfully encroach upon or violate any of the fundamental rights of the petitioners. Your Lordships, the actions of the defendant, Mr. Ratan Murthy, were in the pursuance of their own creative freedom and well outside the boundaries of breaching the petitioner's fundamental rights. Further, the rights under Article 21, that is so-called the decision of horizontal application of fundamental rights, which is propagated in case Puttaswamy versus Union of India and established as well in Kaushal Kishore versus the state of UP. Horizontal application of fundamental rights is possible in case of private entities. But your Lordship, in this case, it must not be held possible, as such application may only apply when there has been, and I quote, a deprivation of personal liberty, and that too by the acts and omissions of another person or a private agency. As it is clearly stated and will be further exemplified by me, that no such deprivation of fundamental rights or personal liberty has been caused by the actions of the defendant. Under my second argument, your Lordships, alternative remedies have not been exhausted by the petitioner.
Before you go to alternative remedy,
Yes, Your Lordship.
the petitioner argued about fundamental rights, three things. He said that the right to freedom of the speech, livelihood, and privacy. So, what is your take on this?
Your Lordships, these are the precise points of my further submission, but to succinctly answer your question, Your Lordship, our personality rights have not been recognized distinctively and decisively by any of the jurisprudence of this court or any of the courts in the Republic of Zindus as a fundamental right. Hence, as per as relation of right to privacy and right to livelihood are concerned, no such rights have been violated under Article 21.
Please go ahead.
Yes, Your Lordship. Under my second submission, I contend that alternative remedies have not been exhausted. Your Lordship, Article 32 stipulates that the right to move to the Supreme Court is by appropriate proceedings and for the enforcement of the rights conferred by this part. This implies that there is no freedom to move to the Supreme Court by all sorts of proceedings, but by appropriate proceedings only. Your Lordships, whenever the state or an instrumentality of the state, clearly defined within Article 12 of this Constitution, is involved, it will be regarded as an issue within the meaning of the public. But when private parties are at loggerheads, it is regarded as an issue within the meaning of common law and must be regarded to ordinary goods. Your Lordships, Article 21 is an interest which is simultaneously recognized as a common law right as well as a fundamental right. Your Lordships, when the interference with personal liberty enshrined under Article 21 is done by the state or any instrumentality of the state or other authorities that perform public functions within the meanings of Article 12 of the Constitution, a claim for violation of a fundamental right may lie. But when the author of an identical interference is a private entity that does not perform any public function, does not fall within the definition of state or instrumentalities of the state within Article 12, the action would lie at common law in an ordinary court. Your Lordships, therefore, it is submitted clearly that the court should not lose sight of the difference between public law activity and private law activity, and is urged to refuse to entertain the claims of the petitioner. Your Lordships, under my second submission, and to answer the queries raised prior, we contend that the actions of the defendant are not violative of the rights guaranteed under Article 21 of the Constitution, as the right to personality is not recognized in the Republic of Zindu as a fundamental right. Any such connotation of a right or mention of personality rights or right to publicity is under a trademark and copyright infringement and has been mentioned in the capacity of a violation of a tort or an infringement and not as a fundamental right. Your Lordships, the petitioners, through their arguments, have failed to establish such a definite connection to Article 21. Your Lordships, further, the cases, if referred to, that are commonly known to claim personality rights are all cases of copyright and trademark violations. All cases, and I contend two to take example clearly. Anil Kapoor was Simply Life, in which the Delhi High Court had made a decision, which was filed in 2023. It had clearly stated that the usage of his name in any form is illegal and might harm his publicity rights. It was contended that the name and his photo for posters modified according to GIFs or any other morphed images is not allowed. Generating images of him, morphed images of him, especially in the context of pornographic photos, is not allowed. And squatting his name as domain names, such as anilkapoor.net, Anil Kapoor Life, etc., was not allowed. None of these arguments raised a connection between personality rights to a fundamental right enshrined under the Constitution. Your Lordships, further, there is no distinctive or unique identity of the petitioner that we have encroached upon. Your Lordships, if you refer to Moot Para 11 of the proposition, yes, Your Lordships. It says that Fiction Flow was the first Zinduan musical album created entirely by an AI by using the randomized feature. Your Lordship, the definition of a randomized feature is provided in Moot Para 8, Part B, where the randomized feature is a feature that enables the tool to create a song or video on its own based upon prior data collected and accessible data available in the public domain using any of its multiple pre-existing filters. Your Lordships, this makes it clear that the album which was made was an original album autonomously created by this AI and does not infringe upon any of the pre-existing rights of MC Bars, the petitioner. Further, it must be made, yes, Your Lordship.
You mean it's not infringement, you say?
Yes, Your Lordship. It is not an infringement of his fundamental rights.
But it is infringement of copyright.
Your Lordships, I am not commenting on infringement of copyrights as the petition is filed succinctly as a violation of fundamental rights. If I were to comment on copyright, then such a case should have been filed elsewhere in an ordinary court. Your Lordships, further, it must be made clear as to the contentions of the petitioner that these were parts of his personality or his persona, and that his personality rights is his fundamental rights and the same has been breached. I would like to state that lyrical styles such as chord progression, harmonies, bars, grooves, beats belong to all genres of music, Your Lordships, and cannot be claimed to be distinctive to one single person. These melodies, harmonies, are essences of music that are combined in several manners and then used by respective artists. There always can be a similar identification between several ragas or several melodies and harmonies, and no one author can claim a right over it or a distinctive right over it. Hence, the claim of the petitioner that this is a part of my personality is clearly unfounded. Hence,
Well, Counsel, if you're saying that this is part of your personality, when you're taking somebody's voice sample,
yes, Your Lordship.
creating something fresh, according to you, is that a violation of his or her personality rights?
Your Lordship, can you please repeat the question?
So when you are, as an AI program, taking the voice sample of Mr. X, using it for creating random music, is that a violation of that Mr. X's personality rights?
Your Lordships, if the voice sample has been taken and has been reproduced in the same format, and then it will be a violation of his rights. But as I will be contending earlier,
So are you trying to say that if AI goes and changes the voice sample, then there is no problem?
Your Lordship, I am not even contending that. What I am contending is the voice sample. In fact, what I would like to state is, what must be stated is that inspiration from an artist does not infringe upon his fundamental rights. What we have done is use a sample of the music available in the public domain like available in any music streaming platform.
Is that part of fair use?
Yes, Your Lordship, because that musical
And which section are you referring to, please?
I'll give you an example
Yes,
to support my brother. Just listen to this. Popular song. Tell me who is the singer?
Your Lordship, I do not have.
Listen on.
I.
Is song made on Prime Minister's voice, Mr. Modi.
Sorry?
It's not Mukesh singing. It's Prime Minister's voice has been mimicked. Artificial intelligence algorithm generative AI created the same song, replacing Mukesh voice with Prime Minister Modi's voice.
Yes, Your Lordship.
So
That will be a violation. This is right.
that's what the people are saying. That's what you read out. Voice. You read that. Your colleague has read out. You have read out. It's saying based on what is this? Plugging effectively his voice. His voice. The singer's voice. Lyrical style and flow for the album, whatever. So, whether it is Sonu Nigam, Shreya Ghoshal, and recently, I can't show you, it is the old film song of Dilip Kumar wearing a lungi Devdas with a kurta, same has been deepfake, Mohammed Rafi song with Shah Rukh Khan. It's been put on Twitter by our own friend Amit Datta. Amit Datta is a copyright lawyer for IPRS and all that. So I simply said, if they have made this, it's a deep fake, number one. Number two, not only the face deep faking, the voice also deep faking. Mimicking the voice, of course the same song they are put here. Mohammed Rafi song is there. The voice is not, the face has been changed. So it's a deep fake. It has been not shot on the Shah Rukh Khan, but it was shot on Dilip Kumar. So what is it?
Your Lordships, like you stated, there was a part of the music and then a deep fake was exactly replaced on that part of the music. Your Lordship, what I'm contending here is an entirely new output.
So have you taken license for this?
Your
Consent and compensation?
Your Lordship.
Yeah. And number two, can't this be categorized as a version recording? You know what is version recording? Remember the clause 31C we introduced in our 2012 amendments, where any version recording after 5 years only can be created. If this is categorized as a version recording, I'm trying to help you that whether this has been created, this deepfake or whatever, the album, after 5 years and within the 5 years of that release. Can you throw some light on this?
Your Lordship, neither is this a version recording, neither is there a direct replacement of one voice or one's lyrics over an already established song and the same has been reproduced, like the song that you just played or the examples that you have
So
given.
you say it's a kind of remix.
No, Your Lordship. It is not a remix. It is
Because
a
remix is also not allowed within parties.
Of course, Your Lordship. It is not a remix either. It is a completely new output generated. How? I will elucidate. Your Lordships, as I have stated, lyrical style, pattern, flow, all of which together composite the song, are not distinctively identifiable only to the petitioner. Further, what we must take note is that alpha real's ability to generate its own composition, its own lyrics, and its own vocals. Neither the lyrics are the same as any of the songs of MC Bars, neither the vocals are of MC Bars, neither the composition of the so-called melodies that MC Bars claims is distinctive to his personality.
It does not copy.
No, Your Lordship.
No, it just created just like you
Your
create and
Lordship.
we create.
Your Lordship.
Without relying on the existing database, pre-created was no learning happened there. No learning happened.
Your
My
Lordship.
question is any learning happened?
Your
Any
Lordship,
data
inspiration-
sets created before the output come out?
Your Lordship, the existing samples of music, to that extent, have only inspired the AI, and the AI, using its algorithm, pre-coded algorithm of recurrent neural networks, to allow itself to adapt to the thinking of humans and how such flows work. Then with natural language processing and capabilities of voice synthesis, has then, using its ability to generate its own vocals, its own composition, and its own lyrics, has created this album.
So why did you say, Mr. Counsel, that if the said voice samples were not there, this would still have been created?
Yes, Your Lordship.
So what basis do you say that? Because the system would not have the voice samples there.
Your Lordship.
Any inspirational work thereof.
Your Lordship, we have access to public domain data and accessible data. We do not necessarily need a plugin or a voice sample to exactly, because we have not extracted his voice or reproduced his voice. His music is available in the public domain. The AI
I give you one more example.
Yes, Your Lordship.
My Bollywood musicians say that it's inspiration. This is the original song, which Bollywood musicians said that I inspired. You know the Hindi song?
Dena Saath Mera Hai. Your Lordships, regarding this, there are three really famous litigations, two of which are committed or filed.
Even my favorite musician, Kopri Nair, inspired so many now. I was traveling in the metro, Italy, with my wife and kid. They was playing songs, you know, the music, tunes, all of the Hindi songs. First we thought it's Hindi song, and then the English words started coming, when music started. The Italian thing. Our people shamelessly inspired and put Hindi words and Hindi lyrics, and our popular Bollywood songs sung by Kishore Kumar, Lata Mangeshkar, Ghantalisala. They said inspiration.
Your Lordship.
So you can't say inspiration when you're copying. You know, it's a shameless copying happening.
Your Lordship, I contend and I respectfully submit, there is no shameless copying happening. Your Lordship, when you dissect the music into separate compositions, separate lyrics, separate vocals, in all the examples stated by you, either the composition was the same and the lyrics were changed, or the lyrics were same and the voice was changed, or the vocals were the same but the lyrics were changed.
Then what do you say? How do you argue that
Your Lordship.
Petronius AI's survey on the 10th leading the generative AIs and LLM models saying that all content, whether videos or songs created, nothing but copying happened. 90% copying only, remaining 10% paraphrasing or learning and creation happened. So how do you argue that? And I don't think your AI is also different from these OpenAI models and Google models and Microsoft models or any other company which has
Your
not.
Lordship, I would request a clarification. In the OpenAI model, you stated that 90%, like that part.
There are 90% copying. Yeah, the AI, whether LLM model or GI model based on the neural network, would have never created the so-called new work, so-called original work, so-called uninspired original creation or expression without learning from the existing databases, existing content.
Your Lordship, learning from the existing databases or being inspired from existing music is an aspect of creative liberty enshrined under Article 19(1)(a). It is clearly held that there must be a balanced job between protecting against shameless copy and being inspired by the works of fellow celebrities and fellow entertainment industry to produce newer works. Your Lordship, let us forget for a second that this was an AI. Let us say this was an upcoming rap artist who, using distinctive composition, distinctive lyrics, and distinctive vocals, being inspired by listening continuously to the songs of MC Bars, had created a new album and it had received just as much widespread attention. Would we still have contended that he has shamelessly copied such acts, such music of MC Bars? No, Your Lordship. Why? Because a inspiration has been taken, a creative liberty has been enshrined, and what I further contend is that nowhere in the fact compromise or the moot proposition is it stated that the voice of the output generated by the AI after being processed by recurrent neural networks, natural language processing, being dissected with a different composition, with the different vocals, with the different lyrics, then combined together to make an album, the fiction flow, was perceivable by the public as the voice of MC Bars.
So finally, you are trying to convince both of us that MCs have no bars.
Yes, Your Lordship. Therefore, I submit, Your Lordships, that there has been no violation of fundamental rights of the petitioner and any such claims are unfounded. If Your Lordships have no more questions for me, I proceed with the third writ petition. Your Lordships, I would like to clarify a mistake made by me at the start. I said that I will be speaking for a total of 24 minutes, but that was wrong. I will be
No,
speaking
no,
for
no,
a
I
total
prolonged it.
of
Please, I'm also culprit. So please.
Much obliged, Your Lordships. Your Lordships, there is the third writ petition is filed by Mr. Ratan Murthy against the Union of India, claiming that the IT Rules 2023 are ultra-virus the Constitution and beyond the scope and intent of the parent act, that is the IT Act of 2000. Your Lordships, as defending the position of the Republic of Zindus, I would like to claim that there is always a presumption in the favor of constitutionality of an enactment, and the burden is always upon him who attacks such a presumption to prove that there has been a clear transgression of constitutional principles. The petitioners have failed to prove definitely any such transgression. As a response, I would like to clarify the position of the Union government under three broad submissions. Firstly, Your Lordships, the IT Amendment Rules 2023 are not beyond the scope and intent as envisaged by the IT Act of 2000. The IT Rules 2023 have been framed in exercise of the powers of the central government under our code, subsection 1, clause ZG of subsection 2 of section 87 of the IT Act, read with section 69A of the IT Act. Further, they are consistent with the scope of section 79 of the IT Act. Your Lordship, section 79 of the IT Act provides what is known as a safe harbor provision to intermediaries from any third-party liability of content posted on their platform. Your Lordships, what must be taken note of is section 79, clause 3, subclause B provides that the third party, that the immunity or safe harbor provision may be removed if upon receiving actual knowledge or being notified by an appropriate government agency or court order that that such information is fake, false or misleading, and if the intermediary fails to remove or disable access to such content without vitiating evidence in any manner.
How do you compare with this safe harbor in the IT Act and safe harbor in the Copyright Act?
Your Lordship.
Section 52, subsection 1C, safe harbor, there in Copyright Act.
Your Lordship, I do not see the connection between the IT rules, ultra-virus, and the safe harbor.
Because it is, that talks about the content, this talks about the, the very basis of the IT violation. They are content violation.
Your Lordship, strictly sticking to my submissions due to the paucity of time.
Okay.
I would like to
Please.
contend only violation of the IT Act and not any provisions under the Copyright Act. Your Lordships, Rule 31B5, which is contended by the petitioners, which is a part of IT Amendment Rules 2023, what it does is delineates the responsibility on behalf of the intermediaries to inform its users of such rules and regulations and to make reasonable efforts or due diligence to curb the publishing of such information by the intermediaries. Your Lordships, further, as mentioned by the petitioners, there is no takedown mandate given to the intermediaries. There is a cause of due diligence, that is to cause reasonable efforts, which includes the most least restrictive measures of making your user regulation in consonance with Section 79 of the IT Act and to issue warnings, disclaimer, or viewer discretion for such content. And this rule, read in consonance with Section 79 of the IT Act, obliges the intermediary to make a reasonable effort and is not beyond the scope of Section 79 of the IT Act.
So what's your argument?
Your Lordship, the argument summarized is that what is
share, post such kind of information. It's reasonable steps to ensure that the users don't do so. Where do you find that under the IT Act? Because the IT Act is silent. 79 is silent on that.
Your Lordship, Section 79, Clause 3 delineates the due diligence guidelines that must be followed to the intermediaries. It is.
Are you familiar with the IT intermediary guidelines rules 2011, which already stipulated certain parameters of due diligence? Are you familiar with the IT intermediary guidelines rules 2021, which stipulated other parameters of guidelines?
Yes, sir.
So in a scenario like this, where does this new need for this new additions come in for them to take reasonable steps? I don't find any substance or any support in in other legislation to your argument.
Your Lordships, the taking of reasonable efforts is within the due diligence, is interpreted within the due diligence guidelines and is not beyond any of the due diligence
They were
guidelines.
arguing the rules are, ultra-virus. She is saying not ultra-virus.
No, Your
She is
Lordship.
supporting.
Absolutely.
Yeah. Rules have been framed as per the substantial.
That's the end of India. We will do this.
I seek to clarify that I am proving that it is not ultra-virus the Constitution
That's what my
and
brother
not
just
beyond
said.
the scope and intent of the IT Act.
Sure.
What I have submitted right now are my arguments for being not beyond the scope and intent
Your
of the
time's up. Already there.
Your Lordship, I would like to state just, can I have a 2-minute extension to summarize my argument?
120.
I'm not going to do it. Okay.
2-minute extension.
Okay.
Your Lordships, just succinctly summarize my arguments that the IT rules 2023 are not ultra vires to the Constitution, as one, they are not violative of Article 19 of the Constitution, as they fall within the ambit of restrictions mentioned in Article 19 subclause 2. This clause prohibits that the use of right to freedom of speech and expression should not be exploited by citizens, even in a way which
With the permission of your Lordships, the Council would like to close the podium for the remarks.
I would like to inform the bench that petitioners only have 3 minutes for their review.
Okay, I hope this will not have 120 seconds.
Again, no additional 120.
No, your Lordships.
Yes,
No,
strictly
no,
because
no further extension.
you just final statement you make in 3 minutes.
Yes, sir.
We're not going to ask any question.
Yes, your Lordships.
We are just satisfied with the both parties.
I would also like to mention that respondents will have 5 minutes for their rebuttal.
Okay.
With the permission of your Lordships, I would like to proceed. Much obliged, your Lordships. Your Lordships, first we are seeking only a limited legal personhood for the application of copyright under the for authorship under the Copyright Act. Secondly, that in a similar manner in which a company, although it is not something which is in existence, it can still express its intent through the actions of the directors. In a similar manner, there can be something which is created for the artificial intelligence, wherein directors, in a similar manner, wherein directors are held liable for the actions of a company, in a similar manner, something can be created. Your Lordships, to answer my respected counsel's question on as to why we have approached this court under 136, your Lordships, there is no fundamental right violation which is taking place due to the rejection of authorship under the Copyright Act directly. We have approached this court under the special leave petition powers because it's a much more broader power, and we are seeking to overturn both the High Court's decision as well as the adjudicating authority of Dunning. Your Lordships, now proceeding to the second issue and the rebuttals that we have to present before you, that the idea of apologies, your Lordships, that the idea that compositions can be granted copyright was explicitly overturned in EBC versus DB Moda, and they have said that only original content can be granted, that compilations can't be granted copyright, your Lordships, and that only original work can be granted authorship under the Copyright Act. Your Lordships, proceeding to issue number 3, the co-counsels have presented that they represent Mr. Ratan Murthy in this case in the fundamental rights issue. Your Lordships, I would again like to bring before the court's notice that the petitions were clubbed together. Albeit there were separate writ petitions which were filed, they were clubbed together. And therefore, as we were representing Mr. Ratan Murthy in the first 2 issues, we therefore contend that we also represent Mr. Ratan Murthy in the 3rd issue also. Because again, there was a clubbing of the petitions and the singularity of the petitions start to be removed because of the clubbing of the petitions together. Your Lordships, moving on finally on to issue number 4. The counsel, my co-counsel has argued that there is a provision of due diligence, but para 14 of the proposition, your lordships, if you may refer to that, one final reference before I conclude, that social media intermediaries like Facebook, Twitter, etc. have to remove any news related to the business of the government. The government is empowered to ask this social media intermediaries to remove any content, your lordships, on social media. This is coercive, and intermediaries do not have the freedom to check themselves whether or not this content must be removed or must be kept up. There is some clear interference on behalf of the government. Your lordships, one final submission. I won't request an extension, your lordships, just one final submission. That proportionality is not being met under the IT rules of 2023, as it is not the least restrictive measure as has been held by the Supreme Court in the case of Anuradha Vasan versus Union of India. Therefore, the action which is being taken must be proportionate and must be the least restrictive measure. With that, your lordships, I would like to conclude my submissions. It was an honor arguing with you. Much obliged, your lordships.
Permission to close the podium.
They have 3 minutes or 5 minutes?
5.
Why discrimination? 3 plus 2, 5.
We took extra time in our submission.
Lordship did not take an extra 120 seconds.
Okay. Then I'm just like a student, I'm asking.
Lordship, now I shall begin with my report.
Yeah,
Sorry.
please.
The Lordship, in contention, has made by the petitioner that the clubbing of the petitions which took place, where all the writ petitions were clubbed, and for the same reason, the petitioner is again in their case the opposite client. Your Lordship, it is submitted before this court that the clubbing of the petitions cannot be taken as a reasonable or as a particular reason to enforce or to say that the petitioner be made answerable for the violation of its own fundamental rights. Again, your Lordships, I ask the bench to refer to para 15 of the moot compromise, where it is stated, explicitly stated in the last line of para 15, that MC Bars claims that his personality right is his fundamental right and the same has been breached. Your Lordship, if the fundamental right of MC Bars has been breached, and as an aggrieved party, it approaches the Supreme Court and by filing a writ petition under Article 32, it is indeed the petitioner and not the respondent as pleaded by the learned petitioners in this case. In response to another rebuttal by the petitioner, they have stated that they have again approached the bench under Article 136 of the Constitution of Zindus, which is in regards to the special leave petition. But your Lordship, in this contention, they are going beyond the moot proposition itself. Again, your Lordship, I would like you to refer to para 12 of the moot proposition. Your Lordship, in the again the final last 2 lines of para 12, it states that the High Court upheld the decision of the appropriate authorities, and as a final recourse, not as an appeal, but Mr. Ratan filed a petition in the Honorable Supreme Court for declaring AI to be a person and effectively results in the decision. Therefore, they are clearly approaching under a new writ petition altogether. Your Lordships, in further rebuttals, it is said by petitioners that they are going for a limited personhood in order to be granted copyright protection under the Copyright Act. Your Lordship, if they are going for limited personhood, that is to say, such rights and exclusive rights of a proper author may be exercised by the person having full personhood, why are they claiming sole authorship under their petition? Why not claim for a co-authorship or even, let's say, limited personhood under the Copyright Act, such as in the case here, so that the rights of Alpha Real may be exercised by an actual person? Why go for sole authorship altogether? Lordship, in further rebuttals, it is stated that, again by them, that in Eastern Book Company versus DB Modak, only original work can be granted. And I totally concede to the above claim as further argued by me under issue 2, The works of Alpha Real are not original under Section 13 of the Copyright Act. Your Lordship, again, it is stated by petitioners that the term business of the central government is nowhere mentioned in the laws or the bylaws of the Constitution or the laws passed in the Republic of Zindus. But Your Lordship, if you could please refer Article 77, Part 5 of the Constitution of Zindus, where it says, Your Lordship, the conduct of business of the Government of India, wherein all such criteria has been clearly defined. Lordship, under the same, it is stated as by them that there is no reasonable classification that occurs under the final issue under the third writ petition. But Your Lordship, there is indeed a reasonable classification between the intelligible differentia and the potential nexus of the IT rules to the parent act, that is the IT Act in the question. Lordship, with this, I end my rebuttals and it is a pleasure.
Thank you, Mr. Counsel and Madam Counsel, for your arguments. While we are deliberating on our judgment, quick question for both the counsels. How many of you used ChatGPT for your arguments? No ChatGPT, no Bard, no Gemini, no other stuff?
Yeah, the first experiment is.
Yes, as a respondent, Your Lordship, we do not permit use.
Okay, fantastic. Thank you. It's been a very nice occasion for both the teams. I put in so many effort.
All of you spoke very well, just like professional lawyers. I'm really impressed. And no one is winning and no one is losing. No, you stood your ground and you performed. You know, lawyer is also a performer. No, yeah, and very good performances from all of you. And of course, a couple of guys were from the backbone of your performances. Silently sitting. I understand they must have done a lot of research and good. Congratulations to you also. And also other participants must have done good work in various rounds. And that's the idea of a moot court.
Exactly, the moot court is primarily meant to give you the experience of the court. And I think it's not just the three persons here, it's the people there who are specifically looking at your skill card, your code drafts, your ability to answer questions, which are of paramount significance. And I think it's a learning experience for all of us as we join hands together. And with AI now coming in, it's going to be a different ball game altogether. By the time you guys are coming into the profession, it will be a complete sea change with the far more new AI tools coming in. But congratulations, I think it's fantastic work done by both of the teams. And of course, fantastic work done by the audience to be there for 2 hours, being quietly listening to the arguments. Thank you, and a big round of applause for the audience.
Who will collect this? Organize this? So I'm a conservative copyright guy, and because the very IP system has come, we can escape on the theory of personality. So even Australian court, the budget rejecting the lower judgment decision of granting inventorship to Davos, Stephen Thaler case, it said it is invention has to be, innovation has to be human ingenuity, human mind, not the machine, not human. So entire my PhD I argued that, and the one is the personality. Person has to be there, natural person. No legalistic or juristic person can be given. And our own copyright office did a mistake in Raghav AA case, anti-Sainika application advocate card. China authorship they gave, and then also the Professor James Ginsberg from the Gurugram University, they invited me to US Asia Comparative Conference and AI and copyright post my PhD. When I got my PhD in this, the conference was organized by Columbia University, New York, Hong Kong University, and Waseda University, Japan. They invited to give keynote address. My friend Shira Karmaka was there, Register of Copyright US, and Jane Ginsberg was there, and the Sai Krishna Balganesh was there, professor. All famous copyright guys were there. I clearly said it was a mistake by the Indian Copyright Office. Kabhi we have to protect of the nation, but galti was the galti action karna chahiye. So, two persons, section 2 I says, two or more persons collaboratively create a work. Then joint authorship review. When you have one machine or one person cannot be given. That is a mistake of that. Another mistake of that, there is no right of rectification. Rest with the register of copyright. Section 45 allows him to do some corrections, typos, typos, address correction, that correction only. The removing the registration from the register, the power earlier was resting with the copyright board, was copyright board based with the IPAB. Now IPAB disbanded in the second tribunal reforms 21. The powers of IPAB is given to all 25 commercial benches of High Court. As per the jurisdiction, because Copyright Office is here, application was filed. The registrar must have moved an application to the commercial bench to rectify, for giving permission to rectify, naam nikal do galti ho gaya bhaiya. That they didn't do. Apart from the personality incentive, why patent has 20 years term? In the 20 years time, they'll give you technology transfer and the exclusive license or non-exclusive license, or a copyright life of the author 60 years. You will get royalties. Incentive. With that incentive, you create more, innovate more. Creative India, innovate India. That's what the National IPR policy says. So machine. One journalist was arguing with me. If they like I was just telling my friend that I retorted to Elon Musk when he wrote on Twitter that digital God, he was mentioning about the digital God, the strong AI, artificial general intelligence going to come, that will kill copyright. Khatam ho gaya copyright. Rahul Gandhi बोलता ना बस खत्म. वो भी बोला खत्म. I said no भैया खत्म. He replied on Twitter that the very birth of copyright took place because of the invention of Gutenberg printing machine. Statute of Anne came 1710. Then Bell Convention of Harmony. And then Rome came because Bell did not address a new invention like broadcasting, phonographs, and the performer rights. And then Geneva Convention came because the piracy was a tape recorder. Address that. And then WIPO Internet treaties came, digital rights management, TPMs and all that. Extending to Internet. So copyright will transform. It will come out with the new ideas to address this, but copyright will never die as long as the original content is created. That's what, nutshell I replied. I've been arguing this only. And recently, my minister, I'm an advisor to the EPIT on all IP matters. So Mantriji gave a reply on this very basis. So whether India needs, you guys were mentioning the Parliamentary Standing Committee. I said no. I will not introduce a new and recognize even a sui generis right. Why India did not introduce the sui generis database justice directive like EU? Because copyright zindagi hai isse originality se. Originality मार के non-original databases दे दोगे. That should never happen. Like you kill novelty, inventive step, and industrial application, patent, तीन मार के सबको patent दे दोगे. Similarly, copyright, that should not happen. And I'll see that as long as I'm alive in government or out of government, I will not allow copyright to be deformed like this, giving rights to non-human. So one guy said, it's coming with a strong way with a sentinel. उसको feel होगा. Feel होना चाहिए. कौन सा रजनीकांत की what is that? वो प्यार भी करने जाए ऐश्वर्या राय से. मैं नहीं दूँगा. Okay. Yeah. Thank you.
Thank you, everyone. It's a pleasure having you.
है ना.